Dr. Agarwal, distinguished panelists, ladies and gentlemen, the last 15 years has seen such rapid changes in the Indian intellectual property landscape, both at the legal level, at the law level, at the level of decisions of courts, the infrastructure, best practices adopted by companies, and so on. Let me take a few minutes to just highlight some very, very recent changes. Let us take speed for a moment. One of the biggest complaints against India used to be that the laws are very slow. It takes a lot of time for courts to decide disputes. Now the Commercial Courts Act was enacted about a year and a half ago. And now, in 1.5 years, the entire litigation from beginning to end can be concluded, because litigation is divided into 8 phases. Each one has a mandatory term. If a person misses on one of the obligations, it automatically goes to the next. Now, one of the matters went up to the Supreme Court. First and foremost, the Delhi High Court held that all intellectual property are commercial matters. Even though trade secrets were not mentioned in the Commercial Court Act, but by an interpretation in a case of Sanofi Aventis, the court said even trade secrets are commercial litigation, and so all of them have the benefit of this fast speed. One of the matters went up to the Supreme Court recently called the Intex case. And the Supreme Court, aware that the Commercial Courts Act had created this fast speed in the High Court, said, we want to treat the Delhi High Court as a model court for the entire country, and we want to treat intellectual property as a model for all other laws, be they family laws or money recovery actions, anything. So, a committee was asked at the High Court level to formulate rules. To cut a long story short, the 2018 rules are now in draft form. Look at the changes being introduced by those rules. Just to give a few examples. Now, you can have service by WhatsApp and SMS. You can serve your opponents by any electronic means like WhatsApp and SMS. One of the steps of those 8 phases which I mentioned was admission and denial of documents. These rules say that along with the written statement, admission denial ought to be done on affidavits. Along with the replication, admission denial ought to be done. So once 2 steps have been eliminated in order to add speed. So, in-camera hearings are now in the rules, which means confidentiality in counterfeiting matters can be preserved. There will be day-to-day hearings. When recordal of evidence, witnesses come from overseas, a day-to-day hearing was necessary. Now that's been added in the rules. We were always an e-court, but to that, now you can do e-filing, which means you can file your lawsuits from your office electronically. Local commissioners that are appointed to record evidence are now obligated to finish the recordal process within a period of 6 months. There will be timekeepers, like the registrar of the High Court, who will ask the parties how much of time they will take in arguments and fix the time. The cross-examination, if there's no facility available in the High Court, can be conducted in a 5-star hotel or any other business premises outside the High Court, which is a very, very advanced step, because it was against the basic principles on which the High Court preserved its records. A4 size paper is now introduced for the first time, making a lot of difference to the convenience of our foreign clients. These are some of the changes. Matters wouldn't conclude. They would get stuck in the finals. So What has happened? Either they would have to be settled or they would go ex parte, but on merits they wouldn't conclude. To add to that speed, a summary procedure of Order 13A has been added, which means at the stage of framing of issues, the judge will decide the defense is no good, I will decree the suit, or the plaintiff has no case, I will dismiss the suit. So this summary procedure means that all cases will not go to trial and they might be concluded in lesser period than 6 months. Then convenience to witnesses. One of the biggest changes came about when you could do video conferencing of a witness who was unable to come to India. This evolved. In the beginning, the rule was that the Indian High Commission's representative should be present at the far end to ensure that the witness is not prompted. Then that was very difficult to achieve, so the court changed the rule and said a notary public can be present. And the court then changed the rule and made it even more liberal and said you can have a wide-angle camera to ensure that there's no cheating at the other end. See how the rule was evolving. Let us take the substantive side for a few minutes. In patents, one of the biggest problems was the Section 8 problem of disclosure of equivalent applications in other countries. The Phillips case and the Roche-Cipla case came along and said, no, you need to show that there was materiality and intent for there to be a blameworthy state of mind or for the patent to be cancelled, not otherwise, which made it far more rational and easier. Then, the fee on sequence listing of biotechnology cases was huge. It was per page, per electronic page. And then there was a writ petition filed on behalf of Evogene in the High Court, as a result of which the law was changed, rules were introduced and said, now there's a ceiling of 1.6 lakhs of rupees, which is quite rational. Another problem, the number of examiners were just 130 in the patent offices for so many years. For 25 years, 130 examiners. Nito Denko, a Japanese company, filed a writ petition. A committee was formed by the High Court with the help of the Patent Office, and the Government of India made a commitment to increase the examiners, and now there are 750 examiners, or on their way to be 750, which means that there's a lot more speed added to the examination process. Computer-related inventions was a big problem, as there was a rule which said that there was a requirement of novel hardware. There was a lot of clamor, as a result of which that was also done away with. In pharma and telecom, the litigation is prospering, as you can see from the cases. There was no IPR policy in the country, and for the first time, with the help of people like Mr. Sabharwal, the Government of India set up a national IPR policy, which is crystal clear and starts with the two words, creativity and innovation. The first opening two words are creativity and innovation. So it sets an entire environment to promote creativity and innovation. Damages were a problem. People would say you cannot get damages in an IP case in India. Now, there are 260 cases of damages, and from 5 lakhs of rupees, 2 lakhs of rupees, they are going to 20 lakhs and going to, in a recent case, 1 crore of rupees for Cartier. Cartier got 1 crore in a recent case, and in 2 pharmaceutical patent cases, much, much more, millions of dollars, but the figures remain confidential. 1 or 2 minutes to see some negatives. The Novartis case in the Supreme Court continued to remain a sore thumb on Section 3D. The IPAB was from November 2015, was not formed because the chairman was not constituted. But the great thing, just a few days ago, Justice Manmohan Singh, a retired judge of the Delhi High Court, was made the chairperson, and the IPAB is back to its functioning after 2 years. On trans-border reputation and trademark cases, the law had developed to a very high level compared to the best for protecting well-known trademarks. But that was diluted recently to a certain extent by the Prius decision in the Supreme Court, where a lot of people are interpreting the decision to mean simply that the evidence was inadequate and that it does not really change the law in a negative way. On copyrights, three things stand out. First, the Delhi University case, where education was, the defense in education publishing was enhanced, and a lot of the education publishers seem to be suffering as a result of that. The music industries, ISRA, the Performing Rights Society for Performers, the Collecting Society for Performers, is having a lot of disputes with other collecting societies. That's something which has come up as a major dispute area. And the overlap between design and copyright in section 15(2), that's a problem which is affecting fashion designers, auto part producers, toy manufacturers, etc. And that, of course, the constitutional validity of that provision is being challenged. Another very negative, which appears to stand out, is the very low patent filing as compared to countries like China, although on the world scale, we are the 7th largest filers in the world. But the question is, do you compare yourself with China or with the others? Finally, you can see, not yet, but IP is becoming a habit. There are many more users. The awareness is huge. There's a much better appreciation of IP, and the wealth generation qualities of intellectual property are now being recognized. And so, it is slowly growing into our culture, and more people are realizing that everybody seems to want his share of intellectual property. Thank you very much.